Welcome to The Explainer. Today, we're unpacking a truly fascinating legal drama, Constitutional Court Case CCT 5/99. Now, I want you to imagine a massive, high-stakes legal battle over the very foundations of a nation's military justice system. We're talking constitutional rights to a fair trial, freedom of the press, the whole shebang is on the line. But then, right at the climax, the entire foundation of the case unexpectedly vanishes into thin air. Seriously, it just disappears. So how exactly does a Supreme Court handle a case that practically deletes itself? Okay, let's dive into this. We are looking at a chaotic intersection of ordinary courts, military justice, and lawmakers. The story we're exploring today perfectly captures the delicate and sometimes messy dance of power between the people who make the laws, the people who enforce them, and the judges who review them. When the rules of the game are changed mid-match, the fallout is absolutely legally fascinating. Part 1. The Secret Military Trial. Our narrative arc begins in a military courtroom. Two members of the South African National Defense Force, Staff Sergeant Pfeiffer and Corporal Buizen, were facing an ordinary court-martial for offenses related to military intelligence. Initially, this was just an internal disciplinary matter, but it rapidly escalated into a full-blown constitutional crisis. Just to give you a sense of the timeline, in December 1996, a secrecy order was placed on the trial. By April 1997, the media was aggressively fighting to get in, and by December 1998, the High Court had fundamentally dismantled the old military justice system. Let's break down exactly how we got from point A to point C. It all started with a pretty drastic move by the presiding officer of the court-martial. On December 4th, 1996, he ordered that the entire proceeding be held in camera. Now, that's a legal term meaning in private or in secret. Not only were the doors literally locked to the public, but the proceedings and the entire record of the case were officially classified as completely secret. And it was this extreme lack of transparency that sparked the broader conflict. Section 2. A Constitutional Challenge. Now, you can't just lock the doors on a trial and expect no one to notice, especially not the press, right? The Freedom of Expression Institute and MNG Media, who published the Mail and Guardian, stepped into the fray. They argued that total secrecy violated constitutional rights to press freedom. But when these media groups approached the court-martial in April 1997 to request access, the presiding officer actually shut them down on a technicality. He ruled that they lacked locus standi, which basically means they didn't have the legal standing or right to appear in his military court at all. Blocked by the tribunal, they had absolutely no choice but to take their constitutional challenge straight to the High Court of South Africa. Once in the High Court, they didn't just ask for the doors to be opened. Oh no. They went after the entire framework of the Military Discipline Code. Their argument was that the military courts, as structured under the 1957 Defense Act, lacked the basic essentials of an ordinary court. They pointed out some really deep flaws: a lack of independence for judicial officers, zero requirements for legal qualifications, and a structure that allowed undue executive interference in the proceedings. And the High Court? They completely agreed. In a sweeping climax to this battle in December 1998, Judge Hlofey declared the challenged provisions of the Defense Act and the Military Discipline Code unconstitutional, invalid, and of no force or effect. The old military justice system was, for all practical purposes, struck down. But here's the catch. Under the Constitution, a High Court's declaration of invalidity regarding an act of Parliament has no actual force until it is confirmed by the Constitutional Court. Which brings us to Part 3. The legislative plot twist. So this stage is perfectly set for an epic showdown in the highest court in the land to finalize the fate of the military justice system. But that final hearing never actually happened as planned. Now, what's really interesting here is what happened right before the hearing. On the absolute eve of the arguments, the ground beneath the court shifted. I mean, think about it. If you're fighting to declare a law unconstitutional, what happens when Parliament suddenly steps in and erases that very law before the judges can even read their final judgment? Well, while the legal battle was raging through the courts, Parliament had been quietly very busy. They passed the Military Discipline Supplementary Measures Act 16 of 1999. This brand new law completely repealed and amended the impugned provisions of the old Defense Act. It established a new military court system designed from the ground up to ensure fair trials, require minimum legal qualifications, and insulate military courts from executive interference. So the law that the High Court had just struck down, it was now officially gone, completely replaced by this new act. But you're probably wondering, what about our two soldiers, Pfeiffer and Buizen? Their trial was paused, waiting on this massive constitutional challenge. Well, Parliament thought of that too. Section 44(2) of the new Act specifically states that all trials underway or pending before a court-martial shall be terminated and may start afresh. Instantly, legally, the pending secret trial of the soldiers was just wiped off the books. Poof! Gone. Part 4. The question of mootness. Deputy President Longa and the Constitutional Court were suddenly staring down a bizarre dilemma. They had a case in front of them asking to confirm the invalidity of a law, but the law was dead. It was repealed by Parliament, and the underlying trial of the soldiers had been legally terminated. In legal terms, this is what we call moot. A matter becomes moot when its significance has been completely lost by subsequent events, leaving absolutely no practical legal dispute for the judges to actually decide. The entire basis upon which the parties approached the High Court had simply disappeared. To solve this, Deputy President Longa used a really straightforward logical sequence regarding Section 172(2) of the Constitution. First, he asked, is the Constitutional Court obliged to hear the confirmation of invalidity? The answer is no. The court actually has discretion here. Next, would confirming the High Court's order have any practical effect on the parties or the public? Because the old law was gone and the trial was terminated, the answer was, again, no. Therefore, the logical conclusion was to simply dismiss the case. There was just no point in ruling on a phantom law. Section 5. The final judgment. With the core constitutional issue dissolved, the court just had to sweep up the remaining loose ends. Initially, when the court was first informed of the new legislation back in May 1999, they didn't just throw the case out immediately. They adjourned the hearing sine die, which is a fancy way of saying adjourned without an appointed date for resumption. They pragmatically paused the litigation, waited for the new act to officially come into force, and only then officially disposed of the matter. Now, there was an incredible, honestly kind of wild side plot here. Shortly before the hearing, it was revealed that acting Judge Gihwala, one of the High Court judges who struck down the military law, was actually a partner in a law firm acting as the correspondent attorneys for the media respondents. The appellants raised an apprehension of bias. The general counsel of the bar argued he was absolutely disqualified from sitting on the case. But the Constitutional Court's response? They noted it, but ruled it was overtaken by events. Because the core law was already dead and the case moot, the court pragmatically decided it was completely unnecessary to investigate this messy conflict of interest. They just moved on. So after all of this, what did this massive multi-year legal battle cost the parties at the Constitutional Court level? Zero. Because the dispute was effectively overtaken by the new act, counsel informed the court that it had been mutually agreed the parties would just pay their own costs. The Constitutional Court made no order on costs, marking a surprisingly peaceful and completely zero-sum end to a highly chaotic legal confrontation. And this brilliantly illustrates the lasting precedent of CCT 5/99. The court established firmly that an order of invalidity has no practical effect and therefore won't be entertained when the underlying legal framework has been entirely replaced by new legislation. It solidified the court's right to exercise discretion and decline cases that no longer serve the interests of justice or good government. Which leaves us with a pretty fascinating final thought to consider. We often think of the Constitutional Court as having the ultimate, unchallengeable word on the law. But in this case, the legislature effectively preempted the judges. If lawmakers can legally erase a massive constitutional battle by simply passing a new law at the absolute last minute, rendering the court's scrutiny completely moot, well, who truly holds the final say in justice? It's a delicate balance of power and one that keeps the legal system endlessly fascinating. Thank you for joining me on this explainer. Keep questioning and keep learning.